So in an employment contract, there's going to be terms that are going to be pretty straightforward. You're going to be able to tell what the salary is. You probably can tell how long it's for. But there's going to be a lot of stuff in there that you're simply just not going to be familiar with. There's going to be things like restrictive covenants. There's going to be information about insurance or what happens if there's a dispute. There's going to be a long recitation of the duties. Those may or may not align with your skill set, your interests, or what you've been promised otherwise. So really want to have somebody take a look at the contract holistically, understand what it is you're trying to accomplish, and make sure that whatever you've been promised is in the writing. There's almost surely going to be a clause in that contract that says that anything's not in the contract, you don't get, notwithstanding any promises from an employer or otherwise. So being able to spot those issues, some of the biggie things that I'm looking for, and they can be tricky, is a restrictive covenant, something like a non-solicitation agreement, non-compete agreement, or maybe something like an anti-moonlighting agreement where you wouldn't be able to work elsewhere, which may or may not be an issue depending on if you're wanting to do other types of work. Other sort of gotcha clauses are large sign-on bonuses that end up having accelerated payback schedules, so you might get some large amount of money, but if you don't work there for a certain number of years, you have to pay it back. Sometimes it's pay it back with penalties or interest. And those things can all be sort of weaved throughout the contract and can definitely be something that in sort of a non-legally trained reading, you just simply don't see or don't understand the import of.
So walk me through what a contract review looks like. You receive the contract. Do you read it and then have a call and just discuss some of it? Is it all marked up? Is it covered in red? How do you approach it?
Well, the first thing I do is understand what the goals of my client is. What are the client goals? Are we trying to get a higher salary? Are you just trying to understand the document? Let's say a client comes to me and says, I want to understand the document and I'd like to get the best terms I can possible. So I'll take we'll have a conversation, make sure I understand those goals, and those are first and foremost in my mind. Mm-hmm. And then I read through the contract. Back in the old days, you might have taken a red pen. Today we use a word processor, track changes, maybe called a red lines. And we're going to put in comments and we're going to make red lines. And my goal, I'm laser focused on advocating for your needs and your goals and wanting to make sure that the contract spells those out as you know, as clear as possible. So we read through it line by line, carefully, put in comments, put in red lines. And in many cases, I'll put in comments just for you so you can understand what a particular clause means, like we described an anti-moonlighting clause. Other times I'll put in a comment that is directed to your employer so that if you, down the road, when we have a discussion about it, you'll be able to bring those concerns to your employer. After I'm done with that, I send the contract to you, and then we schedule a call. We go through the things in the contract, things that maybe most concerned you, and then we would provide the agreement to be sent to your employer.
So the ones I've seen, I like that it's sort of a translation in the margins. So the comments, Adobe comments, let's say, or Microsoft Word track changes, the comments are bubbled throughout, and it's almost like you're translating each clause as you go and saying, this is the impact on you. This is something you might want to talk to your employer about. It's a document for their eyes only because they don't want to forward that to the employer.
No.
But it really is something they could potentially reference back to as well if they're looking to make a change down the road.
Right, exactly. And I'm looking for three things when I'm moving through a contract. I'm looking to explain, as you said, the bubbles and explain the clauses that our clients are inevitably very smart people, incredibly educated, but don't have legal training. So being able to put this in a plain language. Two, I'm looking for those gotcha clauses, those things that are so bad that you should walk away. And then I'm looking for where I think you can get a better deal. So I'm going to spot those things. For example, who pays the tail insurance?
That's a big one.
That's a big one. And there's a lot of confusion on that. I think we've got some articles on the difference between a claims-based policy and an occurrence-based policy. But tail insurance is one of those. You end up, when you're taking a new job, especially as a physician, knowing a lot more about insurance than you thought you'd ever. Mm-hmm. It's not probably particularly interesting, but you better at least have some understanding, because it can very much be an expense at the end of your employment if you end up having to pay for it.
The non-competition agreements or non-competes have been a really shifting area of law recently too. There's been a lot of misunderstanding about whether they're illegal or whether they're still allowed, and I know that varies by state, but one thing that I thought of when you were talking is that as we see more and more hospital system mergers, a physician's practice may now have locations in 30 different places around the Chicago area or the LA area. And so depending on how the contract is written, and LA was a bad example because California does not enforce
I was going to
non-competes.
catch on that.
But in the Chicago area, if you have a non-compete that says you can't practice within a mile of any of our locations, and we have 30 locations, it seems like you might need to relocate if you don't want to work for that hospital system anymore. So I think you've been flagging a lot of those too, but also explaining to people that non-competes aren't just suddenly illegal, and that the FTC is looking to take some action on them. Some states don't enforce them anymore, like California, but that doesn't mean that everyone is on the same page with them.
Right. So you said FTC, that's Federal Trade Commission, and so there's this federal law, of course, applies wherever, and then there's it's the state and where you're going to be working that's going to apply. So you mentioned a state like California. California has public policy against non-competition agreements, but you in a state that maybe has still permits them, like Texas, New York, or Illinois, the FTC might have something to say at a federal level. But there has been a changing landscape, and there's been, I think, some confusion where people say, "Oh, I read that the administration, the federal administration, has said, oh, you can't. There's no more non-competes." Well, that can be a little tricky because of this federal state overlay. So really understanding that, I've also had clients who come to me who have already signed a contract and say, oh, I signed the non-compete, but it's not enforceable, right? The answer, of course, is maybe it is, but the devil's in the details. We want to take a look to make sure that you understand, to your point about the mergers and so forth. A non-compete clause could say, okay, within 10 miles of any location. And that seems, maybe you're okay with that. Well, we would want to put in language to say like within 10 miles of any location now existing, or at the time the contract is drafted, because when there is that merger, or is that expansion, it could be blocking you from an entire area. And unless you want to relocate your family or your entire life, you may not be able to work as a physician, for example.